I will take up the case of Singh versus State. Morning.
Morning. May it please the court. My name is Rachel Reese, and I represent Mr. KENARD SINGH, the appellant in this matter. If I may request 5 minutes for rebuttal.
All right, you may proceed.
This is a case about the complete lack of effective assistance of counsel. The issue before the court is whether or not the trial court erred in denying Mr. Singh's motion for post-conviction relief after presenting evidence in support of the fact that his trial counsel, Mr. Morrow, was completely ineffective. This is a case about...
You're arguing complete lack of efficiency, or because then you can argue prejudice is not required. But didn't counsel successfully convince the judge and had case law to vacate both the sentence and the plea rather than just the sentence?
To go back to Your Honor's first question, the argument is essentially twofold. The deficiency is so great that, yes, technically Mr. Singh would not have to establish prejudice. However, we can also establish prejudice. On to the second point, the issue about the fact that his trial counsel was able to present case law having both the sentence and the plea vacated. That's actually one of the reasons that we believe supports the position that Mr. Singh received deficient counsel, because Mr. Morrow believed that was one of the only options that was available, rather than argue that Mr. Singh's plea and sentence should not be vacated at all. And just as some brief background, this is a case where from day one, it was undisputed that Mr. Singh did not want to go to trial. He made an incriminating statement to law enforcement. And so when he sought the assistance of Mr. Morrow, it was understood he wanted the best plea deal that he possibly could get. And Mr. Morrow did that. He got him a 21-year plea offer, the only caveat being that he had to testify against his co-defendant at trial. Mr. Morrow stood by him while he took his plea, listened to him agree that he would testify truthfully, and then never met with him again. He did not meet with him before the co-defendant's trial, did not go to the co-defendant's trial and watch him testify. And then 2 months later, when the state filed this motion to have his judgment and sentence vacated because he was in violation of the agreement, Mr. Morrow sat in the audience. He didn't even stand by Mr. Singh because he was under the belief that he was not representing Mr. Singh anymore.
Counsel, what authority do you rely on for the proposition that Mr. Morrow was still representing Mr. Singh?
There's a couple of things that were cited in our brief, and mainly the Florida bar rules. However,
which rule?
The specific rule that was relied on. Just give me 1 moment. That is in my other proceedings, Your Honor. However, it is our position that this was not an issue that was in dispute. The original Honorable Judge Lambert found that Mr. Morrow was representing Mr. Singh. Judge Ullman, who presided over the 3850 evidentiary hearing, did not dispute that finding. The only person that ever disputed that he represented Mr. Singh was Mr. Morrow, and his belief that he did not represent him is actually one of the reasons and the foundation as to why he was not effective. If Mr. Morrow was not representing Mr. Singh, then who was? Right. Mr. Singh stood represented by Mr. Morrow. He proceeded to represent him at the most crucial hearing of his entire case, except for his trial, where he ultimately received a mandatory life sentence.
Well, the trial judge required him to.
Yes, Your Honor. He did. However, reasonable counsel would have known once they received the notice of the hearing in this case, setting this case for the motion to vacate the plea and the sentence, okay, something is going on. Something has obviously clearly happened. I should probably read this document. I should probably get the transcripts from this hearing. I should probably find out what is going on, since I never spoke to my client. I never went to this trial. I never saw him testify. Mr. Morrow did not even go and meet with Mr. Singh at the county jail and find out what was going on. I just got this notice of hearing. Why am I supposed to be here? Instead, Mr. Morrow sat in the audience as a bystander of the community, and he even testified at the evidentiary hearing that Judge Lambert seemed very, quite shocked, confused. Why are you not sitting at counsel table? Why are you sitting in the audience? And again, the fact that he was made to stand in does not negate the fact that he was required to still provide Mr. Singh with effective representation under the Sixth Amendment, which he did not do.
Let me ask you this. Are you contending that the trial counsel was deficient in arguing to the trial judge that he should vacate both the plea and the sentence, as opposed to just vacating the sentence?
In terms of that, we are arguing that he should have argued against vacating either, that this was a non-substantial violation of the agreement, and that it was de minimis at best. There were two specific...
Didn't the trial judge make it clear that the trial judge didn't think it was de minimis?
To a point, Your Honor, because the only argument that the court heard was the state's argument. There was never a single fact brought up during this entire hearing about what Mr. Singh actually testified about. The fact that the entire closing argument made by the state at the co-defendant's trial was about Mr. Singh's testimony, and he did secure a conviction for first-degree murder and a life sentence, which was part of the obvious intention behind having him testify. But
the trial judge was present at the trial. The trial judge had taken the plea. The trial judge heard the testimony at trial, and the trial judge seemed to make it pretty clear that he thought the defendant had not, that your client had not complied with the plea agreement. I mean, he didn't mince too many words that I could see.
And Your Honor, respectfully, I think that position on the trial court's behalf was made because of the argument and the facts that they were presented with. Yes, the court was present during Mr. Singh's plea. The court was not present, obviously, during his proffer that was done during a different occasion at the county jail with the state attorney and Mr. Morrow at the time. The court was also not privy to the argument about the additional facts that Mr. Singh did provide.
Well, at the plea, didn't he, wasn't part of the plea that the appellant said that he would give testimony and that was truthful and was consistent with his proffer?
Yes, Judge.
All right, was the judge made aware of the proffer at the plea? The judge asked him about that.
Yes, Your Honor.
Okay. So the judge had some idea of what the proffer testimony was.
Absolutely.
And the judge stated that his trial testimony was different than his proffer testimony because he denied seeing the appellant or the co-defendant with a gun and denied seeing him load the gun. Those seem pretty significant.
The two factual noncompliance issues that the state argued and completely relied on was, as Your Honor just stated, the fact that Mr. Singh had previously identified that his co-defendant had handled a firearm after they had gone to the store to buy bullets. And the second factual noncompliance issue was in regards to Mr. Singh. He had previously said that he had seen his co-defendant throw a rock through a window at the victim's house. Those were two statements that Mr. Singh wavered on and did not fully acknowledge at the trial. His other testimony, though, allowed the state to argue that those facts were inferable, which they did argue. They argued that those two facts that he was not as forthcoming about as it was at his proffer, those are things that the jury could still find based on the other testimony that he had given, and the jury did find those specific things. And that's part of the reason that there's a problem with this situation, is that Mr. Morrow did not make a single factual argument against what the state was arguing.
In determining prejudice, how do we factor in the fact that there was a motion for reconsideration that was denied by the same judge? How do we factor that in determining whether there's prejudice or not?
Absolutely, Your Honor. I think there's a couple points that are relevant to that specific point. The timeline of this case is extremely important to that. The motion hearing in this matter was on May 21st of 2013. The motion for reconsideration was filed by the public defender on November 25th, 2013, 14 days before they were set to go to trial. The rule that was relied on is Florida Rule of Criminal Procedure 3.192, which allows for them to obviously file this type of motion within 10 days, but it gives the court the ability at any point while the court still has jurisdiction to reconsider it. The problem with the motion that was filed is that the Office of the Public Defender went through great lengths identifying how minimal this change in testimony actually was. They identified the fact that Mr. Singh had been threatened by the co-defendant at the county jail, all these issues that Mr. Morrow would have learned about if he had gone out to see him. The problem being is that under the rule, only issues that have previously been presented to the court and have been argued to the court can actually be quote-unquote reconsidered.
I looked at that rule you cited in the brief, and that rule only applies to the state, does not apply to the defendant. So I don't see, am I wrong on that? Because
you're not wrong, Your Honor. However, that is the rule that was relied on by the Office of the Public Defender at the time. So arguably, whether or not that was the appropriate motion that could even have been filed at the time, that is what all parties testified to at the evidentiary hearing, that was the reason why they had done that. And that brings to a great point, is that the elected public defender that was representing Mr. Singh testified at the hearing that if he had been in the same position, didn't have any information about the case, he would have moved for a continuance, and then obviously when that motion was denied, he felt that he had to go back, reinvestigate the entire thing, and file this very intense, in-depth motion for reconsideration because Mr. Singh had not been given the opportunity to plead his case to the court when his plea
would you agree that there is no rule that prohibited the trial judge from reconsidering the motion, reconsidering his prior order?
I cannot disagree with that fact.
Okay. Then are you asking us to assume the trial judge was unaware of the fact that he could reconsider it?
I'm not asking the court to assume that. I'm asking the court to look at the record on its face. The record on its face cites that specific rule. That specific rule that motion was filed under only gives the court, when it receives that motion, regardless of if that's the correct standard or not, it only allows the court to reconsider issues that have already been considered. And all of the issues that were raised by the public defender in that motion had not actually been legally argued and given the state an opportunity to actually rebut those arguments. So I think that the response is, yes, the court's allowed to consider the fact that the motion for reconsideration was filed, it was denied. However, I think that based on the rule and the record before the court, we cannot say that the court did not think it could consider those things. And if the court had considered those things, then I don't think that we would still be here, because Mr. Singh's arguments as to why his testimony had changed and the fact that it was of such a small value in the grand scheme of what his testimony was shows that Mr. Morrow's understanding of what possible outcomes could come out of the motion to vacate Mr. Singh's plea and sentence were incorrect.
If at his proffer, he said he had not been threatened. So if he was threatened between the time of the proffer and the trial testimony, would he have an obligation to say, I can't go through with the plea because, I've been threatened and I'm not willing to do that? Or does he get to just decide on his own that he's going to keep half the, part of the benefit of the plea? He's going to keep the benefit, but not necessarily the obligation.
Yes, Your Honor. And I think that's where a lot of these problems come from, is that Mr. Singh was, I believe, 20 years old at the time. He was relying on the advice of counsel. The problem is that when Mr. Morrow allowed him to accept the plea, he completely abandoned him. He never went and saw him at the county jail. He never would have been able to learn that there were these issues that were actually going on with the co-defendants and other inmates at the jail that were visually passing on threats to him. Any other reasonable counsel would have maintained
contact. So your position is that Mr. Morrow continued to represent him throughout that time, right? But your brief doesn't cite to any rule to us. It only says pursuant to the Florida bar rules. You haven't put us on notice of any specific rule that would say that Mr. Morrow continued to represent him. And so what does this court, what can this court do with such a sort of a vague argument?
And Your Honor, for my rebuttal, I will provide you with the rule. I do have it with me in my other notes. However, I would still rely on the fact that Judge Lambert specifically found that Mr. Morrow's representation of him had not finished. It was essentially, someone gave the example, and I think it's pertinent. This was a situation that was, two things could happen. A defendant takes a plea. One of the terms is that he has to testify against his co-defendant, and either the state allows him to be sentenced that day, or they make sure that he testifies in compliance with the plea agreement, and then he's sentenced at a later date. Mr. Morrow testified at the evidentiary hearing himself. If the latter was true in this case, if Mr. Singh had taken his plea, then was required to testify, and then was going to be sentenced, he believes that he still would have been representing him to make sure that the sentence was fulfilled, or the plea was fulfilled. The same is true in the instant case. Just because Mr. Singh entered his plea and was sentenced on the same day, his plea was not fulfilled, and Mr. Morrow's representation was not finished until he testified against his co-defendant. The state deemed that was truthful, and they decided, okay, now we're not going to do anything to come back and retroactively try to take away the plea that we already did, which is what happened. And again, I will provide the court with that rule, just for not having to go back and forth. I'll do that in my rebuttal. For those specific reasons, it's the appellant's position that the trial court did err in finding that Mr. Morrow was not ineffective and that Mr. Singh was not prejudiced. The record clearly establishes that Mr. Morrow failed to request a continuance, failed to prepare, failed to investigate, and if he had, the court would have been provided with more than significant information to not vacate his plea and sentence, and he would not have been forced to go to trial where he ultimately received a mandatory life sentence. So we would ask the court to vacate Mr. Singh's judgment and sentence accordingly. Thank you.
All right, thank you.
May it please the court, my name is Pam Kohler. I represent the state of Florida in this appeal. Obviously, this court knows that you had already affirmed the trial court's ruling in this case. The issue was raised on appeal, the substantive issue was raised on appeal, and this court found that the trial judge had not abused his discretion by granting the motion to vacate this judgment and sentence, or the plea and sentence in this case. Really, there really wasn't anything that Mr. Morrow could do in this case, even at the beginning of the hearing.
His representation would have continued had sentencing not occurred, correct?
Yes, because, I mean, we cited to that judicial rule procedure that basically he no longer represented the defendant 30 days.
I think counsel's point here is an interesting one, right? I mean, was the sentence final because it was contingent upon the testimony? So sure, he was sentenced, he had his sentencing hearing, right? But the sentence wasn't really final in a sense because he hadn't testified yet.
Well, I mean, he saw it as he was actually glad that the judge had sentenced him because he locked in that 21 years.
I'm not suggesting, I'm not asking about how he sees it. I'm asking about legally what was the sentence, had he been sentenced, was the sentence final?
Well, I think under the rule,
matter?
clearly that he automatically was no longer representing the defendant. Now, he did not just abandon him as the defendant claimed. When they did the deposition on April 11th, Mr. Bachman was there, and Mr. Bachman had been working with Mr. Morrow in this case. It had taken over and talked to the defendant numerous times at the jail before they got out of the case. And then May 2nd, Mr. Bachman and the prosecutors came and talked to him before trial to discuss his testimony.
So even though I mean, your position has to be, I assume, but your position is that even though sentencing wasn't complete, that Mr. Morrow's representation was finished.
Right. He was not his attorney at that point. However, Mr. Morrow did represent him at this hearing. I mean, he was pressed into...
And do you concede that sentencing wasn't, at least in some sense, wasn't complete?
30 days had passed and no notice of appeal was filed, so... Well,
it was contingent on something, right?
It was contingent, but, I mean, it's not like the state files this in every case. I mean, we had only 60 days to file it to get the plea and sentence vacated. We were only asking that the sentence be vacated because I guess the prosecutor wanted to keep the plea. Again, as far as showing that Mr. Morrow did, in fact, prepare for the hearing, it sounds like he got a phone call from the prosecutor after the defendant's testimony saying, you know, basically your guy messed up. He had done some research. At the end of the hearing, he told the judge a couple times, yeah, I read it. So he read something, at least the state's motion. And to be honest, no other attorney, I mean, Mr. Morrow was in the best position to represent the defendant at this hearing because he's the one who knew everything. I mean, obviously a PD would have to get a continuance because he knew they would have known nothing about this case. And there was no other attorney who was in a better position than Mr. Morrow because no other attorney was sitting there in the courtroom and heard the defendant's testimony.
Well, let me ask you this, and I know the prejudice prong is a whole different issue, but as far as deficiency, and let's assume you're right. Let's assume he was no longer counsel after the sentencing, and let's assume that Judge Lambert exercised his authority, inherent authority, if you would, to appoint him at that moment for that hearing.
Right.
Is there any reason why he couldn't ask for a continuance, and should he have asked for a continuance?
Well, the trial court found that he did, in essence, ask for continuance, although he did not actually use those words, but he kept urging the judge to appoint the public defender's office, which of course would require a continuance because the PD would not be ready to go at the hearing, unlike Mr. Morrow, who knew what the proffer was, who knew what he was supposed to do, had talked to the defendant, knew what the defendant had been advised prior to entering his plea, after entering his plea. Mr. Morrow also testified that
if the trial judge was willing to grant a continuance, then the trial judge probably would have had no objection to appointing a different, public attorney, right?
Right, but of
Public
course,
defender.
the collateral judge quoted the judge saying, well, my point is resolving the motion today. And, I mean, the judge was very determined to get that, motion addressed that day. And even before the hearing began, even before the state argued anything, the collateral judge quoted from the trial judge that, he talks about it's frankly his own. I know you weren't at the trial talking to Mr. Morrow. I had a visceral reaction to it as I listened to him testifying, thinking, why did the state make a deal with this guy about to testify about anything? He testified to nothing. In fact, he's testifying not helpfully. I mean, it was fundamentally apparent that he was doing that. Now, this is before the hearing has even really begun. And so when, the time comes for Mr. Morrow, he's thinking, I got to do what's in my client's best interest in this case. And if my client just has the sentence set aside, the judge is going to slam him. So at least if I get his plea and sentence vacated, because I know the judge is going to find a substantial violation because of what was said. So the best thing that I can do for my client at this point in time is to go forward, and that's what he did. And in fact, the state of Florida did offer him a 35-year and a 40-year sentence plea offer, and the defendant rejected both of them. So the defendant could have avoided a life sentence had he just accepted the state's plea offers, and he did not have any minimum mandatories. He was not the one who had the gun. So, and obviously this court has already found the trial court did not abuse its discretion by finding a substantial violation of the plea agreement. So there really was nothing for Mr. Morrow to do at this point in time. He did the best he could under the situation. He clearly did not want to be representing the defendant at that hearing, but he was called in to press into action, and he did the best he could. As is shown by the subsequent motion to reconsider, making those arguments would not make a difference with the trial court in this case. Everybody, it was always considered or was denied on the merits. Nobody ever suggested that this was the wrong rule, that it was untimely, ever. Not in the trial court and not in the appellate court when they appealed from it on direct appeal. So I would submit that there was nothing that Mr. Morrow could do. He represented the defendant to the best of his abilities. He did the best that he could at that point in time based on what had happened. The only one who made a mistake in this case was the defendant by not abiding by his plea agreement. And he would have walked away with 21 years instead of denying that there were any guns or any bullet. And basically, if you read his trial testimony, I mean, and the judge talked about how he talked real softly so the jury couldn't hear his testimony, that he was, basically avoiding testifying and saying anything bad. And then, of course, we have the phone calls that the defendant obviously willfully testified the way he did, that he said, I tried to help him, but it didn't work. I didn't see no gun. I never seen him blow up no bullets, none of that shit, stuff like that. I tried to help him. So, I mean, this is clearly a willful rejection of the plea offer. And, as this court said in Forsyth, if the defendant isn't willing to abide by the terms of the plea, the state isn't required to either. So that's what happened in this case.
All right, thank you.
No further questions. Thank you.
May it please the court. And Your Honor, in response to the rule of law before, I apologize for not having that directly on hand. It was cited by the state. It was the Florida Rule of Criminal Procedure 3.1 111, and it specifically says, the attorney of record for the defendant in a criminal proceeding shall not be relieved of any duties nor be permitted to withdraw as counsel except with approval of court on good cause shown on a written motion or until after the time to file an appeal has expired. As the court specifically, as Your Honor already acknowledged, even though Mr. Singh had taken a plea and was sentenced, his sentence was not finalized. Well,
counsel, I'm aware of 3.111. Your brief says the Florida bar rules, and so but I'm not clear on which Florida bar rule you're referring to. Is there a Florida bar rule?
There's the Florida bar rules that were discussed during the evidentiary.
Establishes your argument here?
The Florida bar rules that are mentioned were mentioned during the evidentiary hearing. Are talking about counsel's representation of a client, when that actually expires, how, when there is a good faith basis to conflict off, things of that nature. And those were discussed by Mr. Morrow and counsel during the evidentiary hearing. I don't have the specific rule for the court at this point in time. I know it is somewhere in the record. As for the argument that Mr. Morrow specifically said that he prepared during the hearing and he was able to briefly look up some case law. One point that is important to note is at one point during the evidentiary hearing, Mr. Morrow specifically testified, and I have it at the record site is at 284. He specifically said, I didn't know anything about the allegations. As far as his non-compliant with in other words, the deficiencies in his testimony, as far as the proffer is concerned, I did not know anything. That is indicative of this entire argument. Mr. Morrow did not sit on the trial testimony. Of course, Judge Lambert had his recollection. However, there was a printed transcript of it now. The things that one might remember versus what an attorney can argue would have been significantly different in this case had Mr. Morrow prepared once he was designated as the attorney, or reasonable counsel would have maintained his communication with Mr. Singh until the sentence was...
The time for filing an appeal, though, had expired already, correct?
I don't think that I can disagree with that. Obviously, an appeal in the situation would not have happened because Mr. Singh would never have wanted to appeal from the judgment and sentence.
I mean, doesn't that give you a problem with Rule 3.111, which, expressly says that counsel is relieved as of the time for filing a notice of appeal expires?
To an extent. So in this situation, I think that it's important to note that obviously Mr. Singh would only have been able to appeal from the judgment and sentence if it was illegal. It obviously was not, sentence was not illegal. He entered into a negotiated plea agreement. However, if he was going to violate that sentence or the plea and his sentence was withdrawn, at that point he would have 30 days to file a notice of appeal. So under the terms of that plea agreement that Mr. Morrow was representing him on, when the plea was withdrawn, it could be argued that that is when the sentence was deemed final. I think that that rule, although it applies, I think that it's gray as it relates to this case. It's not black and white because the way that this sentence was done is not how it might normally be done in every single case. And that's important to note because Mr. Morrow only filed his motion to withdraw off the case, I think it was 4 days before the state filed their motion to vacate the plea and the sentence, which is ironic.
Your position would be that in a situation like this, the defendant can wait until he or she testifies and then file their notice of appeal, assuming they have something to appeal. Then they could file it at that point, no matter how long it is?
Not necessarily. I think that this case is very specific facts. I don't think that Mr. Singh had any good faith basis to file an appeal on the original plea that he took. There was nothing illegal about that.
Sentence.
Or the sentence that he received. The only
But assuming he did, when could he have filed that?
Assuming that the court provided him with that information 30 days.
Which had expired, correct?
Which did have,
which is a problem under the language of Rule 3.111 for your case.
On its face, yes. In terms of this case, I would submit no, and I think that Mr. Morrow's own actions of filing a motion to withdraw, if he genuinely believed that this case was over 30 days after, he would not have felt like he needed to file a motion to withdraw because by the law, he would already have been withdrawn as counsel because of that 30 days expired. My time has expired. I would ask the court to find the trial court's ruling was erroneous and vacate Mr. Singh's judgment and sentence accordingly. Thank you.
All right, thank you both. Court will be in recess.